forest lands. So they said, okay, you can enjoy the FRA pata, but don't use tractor. They have been using tractor and cultivating for the last 20 years. Suddenly they were found. And one or two fellows who are adamant, they use a tractor and non-bailable warrants were issued. That was the tragedy of the contradiction of this thing. So settlement was not completed in 25 lakh acres over the last 3 to 4 decades. And Gram Sabha, FRA, then this is a problem everywhere, but problem is confounded in Andhra Pradesh where the Gram Sabhas are convened by the officers, not by the Gram Panchayat. And rights were vested with the Vanasanrakshan Samiti, not with the Gram Sabha. These are the two apparent contradictions because Gram Sabha is a constitutional body and Vanasanrakshan Samiti is an executive order, a body created by an executive order. Then, of course, the usual clerical mistakes like person's name are different from photographs and all these things. So the intention of the government was that with the FRA, they can make more friends with tribals because these people were earlier friends with Naxalites. Now, after this implementation, there are more enemies than the friends in this. That is the unfortunate thing because the other thing is FRA and FCA conflict. It requires a serious debate. Maybe in this small time I may not be able to tell, but Forest Conservation Act has put so many restrictions on these lands. And some people argue that FRA, there is a preamble that notwithstanding anything contained in any other act, but in the same FRA lands, somewhere else they said that these lands are all reserve forest lands. So this contradiction, requires a serious debate. Maybe in the study this will come clearly. Then the threat of large-scale displacement. Ravi has already told about the mining. There is another serious threat. Serious threat is the Polavaram project where I had some ideas to share with my friend and guru Sridhar, who has just come. This is a social, economic, political. Political is the submergence area is in Telangana, High-Cut is in Andhra. And then constitutional issue is submergence is 5th scheduled area, High-Cut is non-scheduled area. The third dimension is scheduled tribes are lands are getting submerged, non-scheduled tribe lands are getting irrigation. So this is a big this thing. Then the others are industry, wildlife sanctuaries, tourism project, and tourism project in Araku Valley. I don't know whether it has really made any benefit, but the latest documents show that it has spread HIV among the Konds, who are particularly vulnerable tribal groups. Then the latest act, LA and RR Act 2013, it doesn't promise anything special for the MFP gatherers. It says that the FRA patas will be honored, but FRA patas as far as individual rights are concerned, it may be honored, but as far as community rights, how they will be honored, it is not clear. Then people wait for naturally constitutional institutions like the governor, who has a responsibility to maintain peace and good governance. Then Ministry of Tribal Affairs. In one case, the Honorable Minister has intervened and sent a circular as per the powers given to ministry under the 5th schedule. But people wonder why he has not sent similar letter when 275 villages are getting submerged under Polavaram. That is again another political dimension. Then the ST Commission. So these are the expectations of people. And the tribes of Visakhapatnam district, they greet each other like this, pray each other, and they want to get together to fight for their rights. Thank you very much.
Thank you. Now we'll move on to Professor Pavan Mamidi, who will look into the effects of the tribals in this area, particularly what happens to those who are displaced by various types of development projects. The floor is yours.
Thank you. Good afternoon, everyone. In the first place, I wish to thank Namita, my dear friend from Boston, for giving me this opportunity to present some of my research, a part of my research at least. She has contributed several substantive points which have gone into this, and I'm grateful to you for the continued friendship and inspiration. I'm also grateful to Harvard Law School for having given me resources to conduct this research. So what am I talking about? So in the first place, my research doesn't concern tribal areas as such, but it covers the spaces around Hyderabad or Bangalore, major cities where urbanization is happening at a rapid pace. And so my research is located in a space where there is a sort of a rivalry between two orthogonal interests. On one hand, you have the interests of the process of globalization, where people want to acquire land because land is a factor of production. And simultaneously, you also have the interests of people who are likely to be displaced on account of this, right? So the question is whether their ends are mutually possible. Possible in the same space, or whether upholding one would necessarily mean the diminution of the other. So as a quick, let me get down to the core intuition of what I want to talk about. So land is a very precious asset, and finding contiguous pieces of land for purposes of industrialization is very hard these days. If you want to go and find, say, 10 acres of land outside Hyderabad, it's very, very difficult. And one of the reasons why this is the case is that over a period of time, the population has increased, but land has remained finite, and therefore many more people own the same piece of land. And so there's greater number of small holdings of property rights. And so you don't have large pieces of land. But factories and industries and special economic zones are always demanding large contiguous pieces of land. And it's a major asset. If you take, for instance, something like Infosys, a company like Infosys, it owns up to 900 acres of land given to it by different governments, and which at a conservative estimate of $1 million is equivalent to $900 million. And their land asset value is much, much higher than even their intellectual property rights, which is kind of paradoxical, isn't it? So, and they want to acquire more land, right? And one of the sort of challenges that they face is something called the holdout problem, which I'll get to shortly. So broadly speaking, there are two ways in which land can be aggregated for the purpose of industrialization. The first is the government takes over a chunk of land from these multiple holders of property and then transfers it to the private entity, ostensibly to the end of serving some public purpose. And the just compensation is supposed to compensate the people who are dispossessed. The alternative method is the companies go directly to the landowners, say the farmers, and try and purchase these small holdings, right? Now, the government, what it does is it exercises something called eminent domain. And the economic justification for eminent domain is the problem of holdouts. So let's say, this piece of land in front of us is fragmented into multiple holdings. I start going about purchasing small bits of land, right? I go about in a sequence. And then somehow I run into a problem. And the problem is there are a couple of people in the middle who refuse to sell the piece of land. There could be a variety of reasons why they refuse to sell the land. Their ancestors are buried there, or their social capital revolves around living in that particular space, or they just want to hold out because they have strategic interest, because they believe that they can demand a higher price when they discover that there is an ultimate corporate purchaser who wants to acquire the entire piece of land. So there are a variety of reasons why holdout problems arise. Right? So eminent domain is supposed to solve this problem, which is considered to be a market failure in aggregating land for companies. One of the sort of iconic images that often comes up when you sort of want to understand eminent domain is this nail house from China, where one woman held out. She refused to sell her piece of land, right? And this is another happier example from the US, where that lady refused to sell her land. So holdout is a classic economic problem. It's a market failure, and the government seeks to sort of get in. But when the government gets in, there are a variety of problems that come up. It generates a huge amount of political resentment, because the taking over process is a very violent process. It's a very coercive process. People do not have any choice whatsoever. I mean, one day the collector comes and declares that your land has been taken over, and there's very little that you can do about it. And it invites the attention of Maoists, it invites the attention of opposition parties, where opposition parties are strong, and it also might invite the attention of courts in this country, which are still sensitive to the fact that property is not a fundamental right as such, right? So there are long-term costs when companies engage in this practice of leveraging their proximity to the government to aggregate land for them. So interestingly, there's a new breed of entrepreneurs who have emerged, and this breed of entrepreneurs is comprised mostly of Naxalites, and this is one positive example of the good things that the Naxalites do. I mean, I hope you're not recording me for this, but I think it's a misconception that Naxalites are. I mean, if you ask me, the per capita violence of the Naxalites as compared to the police is much lesser, and they're political entrepreneurs who are very good at resolving disputes at the rural level, and they actually create a public good, which is oftentimes ignored. And what this group of people do is basically they mediate between the corporates, and they go to the farmers or the small landowners and start purchasing little pieces of land. And in the event that there is a holdout, what they do is they leverage the social forces of the other people against those who are holding out and solve the holdout problem. So eventually they're actually able to manage to aggregate these large tracts of land. Now, where does the issue of tribals come in? So there was a mention of assigned lands. So when government takes over lands from various people, assigned lands are those lands which have been given to the oppressed communities, the SCs and the STs, and tribals are an integral part of this. For instance, I did a case study of a village called Polepalli, where there are several tribals whose lands have been taken over. And because these lands are assigned lands, somehow the government finds a perverse logic of compensating them with far lesser money than they would the other people who are non-assigned landholders. So what happens is, a policy that was meant to protect the lower caste has, in the end, become something that is actually detrimentally affecting the lower caste people, including the tribals. I mean, for instance, Polepalli, where close to 3,000 acres of land have been taken over as way back as in 2000, it is reported, I have some activist friends there, it is reported that close to 60 suicides have occurred there, which is a staggering number. It's a human tragedy that has happened there. So the government method seems to somehow impose a huge social cost, which in some sense is sought to be resolved by these alternative political, legal entrepreneurs who come into the field and try to resolve holdout problems. So this is more or less what I was saying. So the question is, where is justice? Wasn't justice meant to better the stock of the poorest, right? I mean, this is the Maximin principle. The Rawlsian Maximin principle would tell us that you should take up a policy which has the benefit of bettering the lives of the poorest or the worst off, and that doesn't seem to happen here. So the policy tends to be a very draconian one, and the alternative is the market method, a market that is not sustained by the government, but a market that is sustained by the community, where entrepreneurs go and resolve the holdout problem. right? So how do these people actually solve these holdout problems? In the first place, they go about making secret purchases. They don't indicate that they're going to aggregate the land for some corporate entity, but that they are purchasing it for their own private ends. And then the information comes out that that there is actually a concerted activity to try and aggregate land, and that's when people start holding out. In other words, it's the very same people who otherwise would experience great degree of coercion can now start demanding a much higher price, right? Because they can because now the coercion is not as much as it was earlier. They still have the freedom to either sell or not to sell. The only pressure that they feel is obviously from the community. And it is also argued that these so-called entrepreneurs, these intermediaries, also leverage extra-legal measures to coerce those who are holding out. And that's absolutely a fact of the landscape, right? So one of the hypotheses that I started off with is that the experience of coercion by farmers is lesser in the small-town lawyers method than in the eminent domain. So it's a marginal improvement over the government taking over method, but nevertheless, it is an improvement. It still sort of gives a residual sense of choice to the poor people who can decide whether they are going to sell their land or not. Ultimately, what happens is their neighbors who are going to come up, their neighbors are going to come up to them and say, hey, if you don't sell this land, we are all going to suffer because of this. So it's a community pressure rather than a state pressure, which does not give you, which leaves you with very little choice as to whether you can sell your land or not. So take, for instance, some of the evidence that I collected. I collected quantitative evidence to compare the movement of prices. And this is the movement of prices in the alternative method, where, you see three curves here. Ignore the first one and the third one. Just pay attention to the third one. You see that the price is actually gradually increasing, right? If you were to consider the price that the government would give the landholders, it would come somewhere here, right? And the suicide line would be somewhere here, which is the price that is given to the SCs and the STs. So the market method, in some sense, which is sustained, again, I qualify, by the community, is somehow producing somewhat at least better results for the poorer people than the government is. So this is sort of the central intuition. This is my central sort of thesis in my paper. So let's not go into some of the math that I did here. So how can these intermediaries, how do they produce this kind of a trust? A lot of these intermediaries are drawn from this very same community. They are the same SCs and STs who have acquired a law degree, or these are the Naxals who have gone to a law college in private and acquired a law degree. They're the negotiators. They are deeply entrenched in the society. They can leverage the social norms, and they can solve the problem. So it's a sort of a negotiated outcome rather than a coercive outcome, which helps in resolving this problem. So ultimately, there is coercion in the market method as well, because the society is coercing those who hold out to sell as well, right? So now you have to compare the two types of coercion. On one hand, you have the government coercion, which leads to suicides, and then you have the other kind of coercion. There is coercion. I'm not denying the fact that there is coercion, but it seems to be more targeted, and purely from a sort of a utilitarian perspective, I would argue that there is lesser coercion, and that it is a somewhat of a Pareto improvement over the government method. So in some sense, my story is a slightly positive story about how sort of negotiation entrepreneurs, political entrepreneurs, aided by some training in law, aided by some sensitivity to social justice, are able to actually solve this problem and reconcile two competing ends. On one hand, the demand for land, and simultaneously the possibility of compensating people who are dispossessed of their lands. But the question is, does it ultimately solve the problem for these SCs and STs? No, I don't think so, because I have seen in several instances that these people get these higher prices, but they end up spending the money, or it's too little to find alternative sources of livelihood because the transaction costs are very high. So, so my story just tells you a sort of a marginally positive story in terms of indicating that there are potential improvements over government involvement in takings to sustain this process in this landscape. That's my sort of central story. So, in conclusion, I want to state one thing, and that is, if you want to protect the spirit of assigned lands, no one, not even the government, should be allowed to take over those lands. Either that, or alternatively, you grant them property rights which can be protected. Do not have a system where you give poor people assigned rights and then take away the very fundamental component of property rights, which is your ability to transfer it and monetize on it. And I think that is the sort of the core issue with assignment of lands in an imperfect manner. So these are imperfect property rights. Either you create them in such a way that you actually live up to the spirit of why you created those, and that is not to displace them. May it be a company, may it be any other reason, do not displace them. Either that, or give them perfect property rights and allow them to monetize it and then sell out, and then perhaps at least have a hope of retaining an alternative source of livelihood. That's my sort of central thesis. Thank you.
Thank you. Meanwhile, Professor Sridhar has arrived. He's now the Central Information Commissioner, posted here in Delhi, and as I said before, he has a background in law, and before that in journalism, and with a particular focus on the right to information. So please, the floor is yours.
I think you have to transfer it here.
And friends here, after listening to two of my friends who presented two different angles of governance with reference to law and land rights, I think I'll be continuing the theme, but from the perspective of implementation of law, with governance as the theme. I need not explain the importance of land and the tribals. And the problem is the land of tribals is, as explained by Professor, my colleague V.N.V.K. Shastri, it continues to be under the occupation and control of non-tribals. And the support from political system and government machinery is obvious in spite of the law. And that is why the title, Law for Tribals and Land for Grabbers. And the tribals are reduced to just the subjects of academic studies and reports. We are doing it. Now, my friend must have already explained you the genesis of laws that are for protecting the tribal rights. Alluri Sitaramaraju from Andhra and Komaram Bhim from Telangana, they fought for tribal rights. And AP government conveniently ignores Bhim. That's an issue again. One of the reasons for the separate Telangana movement. And they neither respect Alluri Sitaramaraju in reality. So 1917 is the law where the transfers between tribals and non-tribals, transfer of land is prohibited. But there was one chance of transfer, that is with the permission of agent. Then in 1959, the first post-independence legislation, it prevents transfer of tribal lands totally. The purchase of tribal lands is prohibited. This was extended in 1969 to Telangana, another major issue. By that time, most of the non-tribals from Andhra occupied their lands, and a major problem, that is a fallout of Major. Then Act 1 of 70, which is very popular because of its controversial implementation and non-implementation. I remember the past governor of Reserve Bank, Mr. Subbarao, was collector of Khammam district. At the time, I was a journalist. And he raked up all the issues of occupation of tribal lands and started implementing Act 1 of 1970 in 1980s, early 1980s. When Chief Minister came for a visit to that town, Khammam, all the non-tribal powerful lobbies surrounded the Chief Minister, and they were bidding a price for transfer of the collector because he was implementing Act 1 of 1970, and he was ultimately transferred. By the time I published my interview in newspapers, the collector was out. Then this law was Act 1 of 70 says transfer of land between non-tribals to non-tribal also is prohibited. Then it was challenged. Supreme Court came to the rescue of tribals and said, in the larger interests, it can be there. Such a law can be there because it's a class of its own. If you have a reasonable classification, equality can be exempted from. Then in 1971, it was made a crime, the new penal legislation, which says if you occupy the tribal land, it is a crime punishable with 1 year jail and rupees 2,000 penalty. Once it is recognized, defined as a crime, any ordinary police station can receive a complaint and anybody can give a complaint. If it is a cognizable offense, it will be a serious offense. But the great wonder is not even a single case is recorded. And one more provision under this legislation is any person can file a complaint. This is the basis of public interest litigation. Generally, the law insists that aggrieved person should come, locus standi. What is your problem? But here, it says even though you are not aggrieved, you can represent the other persons. If you are a public servant, you can bring the issues to the court of law. Or any person, any active person can bring the issue. But this is the situation. A similar provision is not available in the enactments which regulate assigned land transfers. Then the problem is lack of governance. This is the major problem. Special Deputy Collector is supposed to be the lower court for the LTR violations, and Collector is the first appellate authority. That power has now gone to Project Officer ITDA. The revision powers are with the government, and who is this government? It could be either Minister, Cabinet Minister for Tribal Welfare, or Principal Secretary Tribal Welfare. And I remember one minister recently reversing the pro-tribal orders given by the two adjudicators below and benefiting the non-tribal. Then according to official figures, 48% of the land in scheduled areas of Andhra Pradesh is either owned or controlled by non-tribals. People dispute it even today. According to today's figures, official statistical record says it is more than 52%. But unofficially, they say 90% is under occupation. Till 1976, Lambadas were not tribals. Then their influx from Maharashtra after 1976, and non-tribals from Krishna, East Godavari, West Godavari, and Guntur districts, they increased the number of grabbing cases. Then, if you look at the statistics of implementation of this legislation between 1959 and 2004, approximately 76,000 cases were filed in 45 years, and 33,000 cases went against tribals. That means legal disposition of tribals and legal authorization of non-tribals in the tribal lands. And how does it happen? With a judgment. What is the basis of that judgment? One Sada Bainama transaction, that means transfer of land on a single white paper, plus a sheet which is called Pahani, the land record, of that year, the year in which he filed a petition, not year in which he took the land. Allegedly, he took the land. The transaction is supposed to be old transaction so that you will not come into the net of land regulation. That means the paper should be at least old enough to reflect that it is a 45-year-old paper or 3-decade-old paper. But this man comes with a fresh white paper with a latest Pahani record, which shows the transferee as the holder of the land, possessor of the land. And the judge, the so-called special deputy collector who is supposed to adjudicate, doesn't even ask, is this an old paper? Where is the original Pahani record? Come on, show me the other person is the owner and you are not till so-and-so date, and you are the owner from so-and-so date. He doesn't even ask those primary details, and he will simply issue an order. Most probably the other party, that means the aggrieved party, the owner of the land, original owner of the land, or so-called complainant, is totally absent. So it's a one-sided judgment, baseless judgment, are based on a fraudulent paper, fraudulently not looked into. So entire thing is a fraud. And nobody comes to their rescue, not even Legal Services Authority. None is there to oppose them in appeal, take them in, oppose in the lower court or take them in appeal. Then my students, they studied 8,000 cases. They discovered these manipulations. They did not do anything. Look at those papers, that's enough. Open the files, you will discover it. You need not dig anything, or you need not be a detective. One latest copy of Pani, yeah, that's what I told you, a deed of transfer of immovable property on a white paper. Then you have a Pahani. You know how the Pahanis can be made. Even a fresh newspaper is visibly considered as a 50-year-old document and nobody questions it. Then they look at this. Res judicata has one principle in Civil Procedure Code, which says that if once it is decided, don't rake it up again, don't reopen the litigation. It is a public interest principle, but they use such a fraudulent adjudication will be treated as a final adjudication. There is one interesting presumption in law, that is, law of correctness of the judgment. Every judgment is presumed to be correct unless and until it is challenged and disproved in appellate forum. And because of this presumption, an unchallenged judgment remains a justified order, and that will be blocking further disputes in the name of res judicata. Res means already adjudicated. Res judicata means already adjudicated. You can't reopen. Balagopal, we know that civil rights activist, very upright personality. He fought for the rights of the people against res judicata. Nothing happened and nothing happens. Then another tragedy is the cases which are decided in favor of tribals, they are not implemented. Not even a single acre gets transferred to tribal, in spite of the order. The machinery works with great enthusiasm to support a grabber, and the machinery is lethargic and very human, with technical due process questions to resist the ooster or grabber. Every minute the police has an authority to look into, and every minute you can take up the case. Res judicata doesn't work here. Res judicata is only for civil wrongs. Then why don't you use criminal law? Question the principle of res judicata that is blocking the implementation of rights of tribals, and why don't you implement the law is the question. It is used by public servants to support criminals in tribal land grab cases. That is the problem. Every fresh offense needs to be registered at every commission of crime. 170 provides for a presumption that the non-tribal occupant violated law. He has to rebut the presumption by proving that he was a bona fide purchaser before the prohibition. He will never do it. The burden of proof in 1959 was with tribal and tribal department. In 1970, it is shifted to accused. But in fact, the burden remains on the tribal, and the entire machinery is very, very favorable to non-tribal.